The torts question from July of 2003 really is quite a difficult problem. Like many of the short fact patterns, you've really got to outline carefully and spot the issues if we want to do a really good job on this question. As always, let's have a look at the call of the question. 1. Is Paula likely to succeed in her suit against KXYZ? Discuss. Well, it's civil litigation, and we've got a media defendant. I suppose it's possible that this could be a contract dispute between Paula and some radio or television station, but more likely it's going to involve a defamation claim or something else relating to Paula having a problem with the content of something that KXYZ put on the air. In Call of the Question 2, we find out about two other lawsuits, Mayer versus Paula and Mayer versus KXYZ. So before we even read the fact pattern, we can see that we're dealing with three lawsuits. In each lawsuit, the plaintiff is going to have one or more theories of liability. And as well, the plaintiff is going to have one or more prayers for relief. And that applies to each of these three lawsuits. So after dashing off perhaps a quick little scratch outline based on the call of the question, we go to the top of the fact pattern, realizing that, as is the case with all short hypos, we've got to carefully find a home for every detail. Now in paragraph 1, we meet Paula. She's the president of a labor union, and Stan, someone who is not a party to any litigation. We find out that there is a dispute between this labor union and the city government and its mayor. An unknown person, who also doesn't end up being a party to the litigation, secretly records the conversation between Paula and Stan. That secret recording looks to me like a potential invasion of privacy. But read on. Notice that this conversation that's recorded is one that the parties to the conversation intended would be kept secret. During this secretly recorded conversation, Paula whispers to Stan that Mayer is a crook who voted against allowing us to build our new union headquarters because we wouldn't pay him off. That statement is potentially defamatory. We don't know if it's true or not. If it's false, there's no question that this would be a defamatory statement. In paragraph 2, we find the unknown person sending this conversation to the radio station. The station knows that the recording was made in secret, and they broadcast the conversation right after they get the tape. So now we've got a pretty clear idea that KXYZ will face possible liability for invasion of privacy from Paula and potential defamation claims by the mayor. In paragraph 3, we find Paula suing KXYZ for invasion of privacy in publishing her conversation with Stan, and Mayer is suing for defamation. So here they spoon-feed us the causes of action. Our job is going to be split them up into elements and then consider the facts. So remember, invasion of privacy isn't a theory of liability. It's an umbrella under which are contained three theories of liability. So now please turn the page and have a look at the outline that I've written, and you're going to see right away that the key outlining move here is to consider invasion of privacy as an umbrella and to have separate sections, each for public disclosure of private facts, intrusion into seclusion, and commercial appropriation. So the black letter law that you have to know to do well on this fact pattern is the details of invasion of privacy. Memorizing long definitions isn't going to help you here. Understanding how the law is constructed will help. Notice in the outline, I consider the radio station's defenses, and ultimately I'm going to conclude that the radio station will be unlikely to face any liability. Next, I focus on the mayor's action against Paula for defamation, Paula's potential defenses, and then I reach a conclusion. Finally, the mayor sues the radio station for defamation. I consider the defenses of the station, and then finally I reach a conclusion. Again, finding for the defense. briefly, let's have a look at my answer. And although, again, I'm not going to read it to you, I want to focus your attention on some aspects that I do think you will find instructive. Once again, look at the very first paragraph that I write under the first lawsuit, Paula versus KXYZ. Notice how I lead with the facts. And just as I counsel you never to write a lot of boilerplate definitions, I also advise you don't spend too much time merely reciting the facts. This first paragraph is about as close as I ever come to reciting a great deal of facts. But I focus the reader's attention both on the facts and on the law, and I indicate that a successful plaintiff alleging these theories is going to be able to pursue both compensatory and punitive damages. So I focus first on invasion of privacy. Notice how up front I indicate that invasion of privacy is an umbrella for 3 different theories of liability, and then I go into each one of them. I talk about public disclosure of private facts. And here again, I do more than merely recite the facts. I explain the legal implications of the facts that I'm concerned about. Next, I turn to intrusion into seclusion. And here again, it looks as if Paula intended for this conversation to remain private, but instead it was recorded, and instead KXYZ chose to take advantage of the misconduct of the secret recorder and broadcast the tape. Finally, I focus on commercial appropriation, and here I am presenting, I think, a fairly subtle consideration of commercial appropriation. Usually, what we think of under commercial appropriation is somebody who is photographed, and then the photograph is used in an ad or something like that. Here, commercial appropriation is a little bit less distinct. We've got, presumably, a commercial broadcast outlet, broadcasting an audio recording that is newsworthy and presumably profiting by selling commercial time around the story. And I think it is probably not a great theory. But I think you'll agree that my analysis is thoughtful and well considered, and not too long. Next, I turn to the defenses of the radio station. And here we get our first look together at constitutional law, because there's a First Amendment speech issue tucked into this torts fact pattern, and together we focus our attention on it. And you're going to see I spend more time on this defense than I spend on the theories of liability. How come? Because it's more complicated, and because I think it requires this attention in order for the analysis to be complete. I conclude that the plaintiff probably is going to fail in her lawsuit against the radio station. Now, I have seen passing answers to this question that reach the opposite conclusion. I would suggest that my answer is in the mainstream of what passing answers were. However, I do admit there were passing answers that reached the opposite conclusion. We're a lot more concerned about the comprehensiveness of our issue spotting and the thoroughness of our analysis than we are about whether or not we get the right answer. Next, I turn to the lawsuit between the mayor and Paula. This principally is a defamation claim, and you'll notice within defamation, I don't break it up into elements and focus on the elements separately. I do it in a more compact fashion. If you chose to break it up into elements and then consider each element, I'm certainly not going to fault you for it. But to be honest with you, I'm not sure there's time to do it. So I focus on the theory of liability, and I focus on Paula's defenses. The central one of the defenses could be truth, but the fact pattern doesn't tell us whether or not the statement really is truthful. We don't know if her allegations are true. So obviously I find it hard to reach a real conclusion other than to indicate that the result is going to depend on whether or not the statement that Paula made was true. Next, I turn to Mayer's second action, his defamation case against KXYZ. And here I focus on the definition, believe it or not, for the first sentence, and then I focus on the defenses. In the end, I conclude that the mayor's action against the radio station probably will fail, and I indicate why that is. Here again, I think you'll find that the conclusions I draw, both in this fact pattern and to all of the others that we're going to review together, are within the mainstream. I'm not picking a minority position and then trying to defend it. What I'm trying to do is reach the conclusions that the majority of successful applicants reached. I hope you find my analysis to be helpful, and I'm sure that you're already looking forward to the next essay question you're going to review.